The murder case of former Bafana and Orlando Pirates goalkeeper and captain continues in the High Court in Pretoria today. Sergeant Thabo Mosia wrapped up his testimony yesterday. A new witness is expected to take the stand. For analysis ahead of the court proceedings, we're joined by legal expert Mpumelelo Zikalala from Zikalala Attorneys. Mpumelelo, good morning and thank you very much for your time as always. So finally, months after he first gave his evidence in chief, Sergeant Mosia has wrapped up. But some say his testimony has left more questions than answers, with even Titi Tobani going as far as saying if it were up to him, he would actually charge him for perjury and defeating the ends of justice. What did you make of his testimony in these past 5 months?
It definitely shows that we, for lack of a better word, you can't really attach the word of an expert witness according to what he has provided, the evidence that he provided thus far. Let's remember, an expert witness would come in and say, this is what I'm ought to do based on the education, skill, and experience that I've acquired. This is the best way of collecting evidence in these particular circumstances. I've used the same way. So whatever which I'm going to deliver to the court is exactly what happened on the day. It's going to help collaborate whatever that the state is saying and possibly link the 5 accused which are in the witness box. Anything contrary to that, anything which shows that you actually provided a service which is substandard, basically means that the results which are going to provide to the court are substandard, and the court can't really rely or place any heavy weight on the evidence in which you are going to provide. So instead of assisting the state's case, I think this expert witness has thrown in so much reasonable doubt into the evidence of the state's case that if we were to conclude the matter today, I don't think that the accused would be found guilty.
Does this then not compromise the probative value of his testimony? Because if I remember just that term expert, it was quickly crushed then when we had Advocate Mshololo going on to say, in fact, you qualified or got your qualifications that make you perhaps an expert after attending to that particular scene.
The one thing which would have saved that particular crushed term of being an expert is how then did you conduct your investigation, which is the most important one. We want to make sure that after you have secured the crime scene, no one actually tampered with the crime scene, so that the information in which you are extracting is the true reflection of how the crime scene ought to have been, and the assessment of that particular crime scene would be the results which are unfettered or which are not compromised in any particular manner. So if you are going to come and say you've provided mistakes, you didn't do certain things which are crucial in you being an evidence collector on that particular day, we are not going to assist this court in any particular manner. In fact, you are going to lead us to having more questions rather than answers. You're not assisting anymore. This helps the defense in terms of throwing in the doubt which is required, but it does not help the state, because the state has a burden of proof of saying the evidence which is going to be provided by the expert witness must be so strong and so plausible and so probative that the only explanation that can be derived from that particular evidence is that the expert witness is telling the truth. If there are instances where the expert witness is not telling the truth or did not do a good enough job in the collection of evidence, it throws in doubt. At the end of the day, when the court is making a proper assessment of how these matters should be, they are going to say, all the seeds of doubts that you've planted during your cross-examination can only lead to a blossom, a not guilty verdict, which must come at the end of the case, because you have failed to prove that the thing in which you are trained to do, you have provided and executed it in a manner in which you are trained, the experience that you have got, which could have assisted this court in arriving to a conclusion. Due to your incompetence, unfortunately, we can't bring a guilty verdict to the people who are in the accused box as we speak.
And it's very unfortunate because one could never know. In most instances, it's not that those that are found not guilty are in fact innocent, but it's about who advances the best argument. So this presentation leaves a lot to be desired insofar as he's concerned. But when we look at these 5 months, there have been a lot of things that have happened. They've lost one counsel, Advocate Def, who's no longer there. His conduct was also the subject of much debate across the board, even among legal professionals. But it seemed now, closer to the end, that even if we look on social media, it's as if to a certain degree, he's being exonerated, that perhaps the line of questioning was taking them somewhere insofar as getting those concessions that they needed. Because Sergeant Musia now was saying that, in fact, that time lapse of 4 hours was a bit of a concern. But when it was posed to him by Advocate Defu, he went on to explain that I take it that I was called late to the scene because a priority for the family would be to rush the victim to hospital and save his life. He had all sorts of versions as to why possibly he was called late. But we're now hearing that, yes, he actually does find it quite concerning.
I think the time lapse will also edge in the manner in which a person is answering the questions while they're in the witness box. If all the questions are posed on one day, you have one state of mind on the day, and the state of readiness may differ from one day to another. But I think the two different strategies from what has happened previously and what was happening, for example, in the last 2 days, is that the compliance with the Criminal Procedure Act has been more on the side of Advocate Mxololo. The strategy has been, I want to follow the procedures to the T so that at the end of the day, I'm able to extract the truth which I desire from this particular client. Another thing which we must consider that you've stated at the start of the conversation is, if I was the Minister of Police or even the Commissioner or even the head of the NPA, I would be very worried, because it seems as if the way or the manner in which this investigation has been done, it is writing a clear and a perfect manual of how not to conduct an investigation. They should be asking themselves, with all the discrepancies that have appeared in this particular manner, how can then we improve and say to our investigating officers, make sure that when you conduct investigations, these are the core things in which we are going to cover. This is the practice in which we are going to cover, to make it easier when we go to court and we're able to deal with all these particular matters, or we've closed the loopholes when loosely translated. And from the side of the NPA, we then say, what exactly did you consult about? We know that consultation is not the actual feeding of the witness, the evidence in which they're supposed to say. But these are the type of questions which should be probed during the consultation phase, so that we are able to piece in the pieces and say, yes, this is going to work, this is not going to work. Let's make sure that we put this witness as our star witness, or we say, no, let's reconsider, you are not going to suffice the reasonable doubt test when it's being assessed on you. So let's let us put you on a back burner and look for somebody else. I think there are lessons to learn, especially from the side of law enforcement agencies and the NPA. But for now, the defense is making a very good job of planting those seeds of doubt that at the end of the day are going to deliver or may deliver a verdict of not guilty.
I hope that the minister does actually take it as you see it, that it is an opportunity to perhaps strengthen capacity within the force, because what we really saw seemed like a force that is on autopilot. When you're called to the scene, you do the bare minimum. Whatever you don't find, you don't find. And then at another time, somebody else may find the preservation of evidence, even just your own concern as to why is the place cleaned up, because it is a crime scene. It remains an active one if police have not arrived and cleared it. I mean, those type of issues that were brought up, it seemed as if Sergeant Musia was at pains to explain to them that my job starts here and ends here. Confine me to what I was there to do. Don't try and plant scenarios and say that perhaps it was tampered with. That is not for me to decide. It's for the detectives and everybody else. Just confine me to gathering the evidence.
But as an expert, you are also taught how to identify if a crime scene has been tampered with. So as an expert, you are then given ways and means and tactics to ensure that whatever evidence which you are going to find there and go and test at a later stage, or prepare for that evidence to be tested, you must remove any elements of tampering which are going to come into that particular piece of evidence, which is why it was crucial for him to answer those questions and say, this is what I have done in order to preserve the integrity of the crime scene. This is what I've done to preserve the integrity of the various evidence items in which I've been able to obtain. All that has been recorded in my statement, which ought to remain the same regardless of the time and space in which you draft it in. Yes, we are human beings, we can make mistakes here and there, but those particular mistakes must not be core mistakes. In this one, the most obvious and blatant one is being directed as where to look and where not to look. It then means that whatever which you are going to produce, it is not your independent expert analysis. However, it is analysis which had been tampered with or influenced by another individual. So if we did not look in other spaces, it means we have already lost a piece of evidence. We can't use it at a later stage when it comes to proving the guiltiness of the individuals or proving what exactly happened on that fateful day. So those are the type of things in which they were supposed to come to court and say, we have ironed out and this is where we are. But another problem which is emphasizing, which is showing us as members of the public, is that there may have been a lack of proper and meaningful communication between the law enforcement agencies and the NPA in this case. Evidence of that is the appearance of these two dockets, which have not been mirrored together or assessed combined or in simultaneously, so that at the end of the day, you are able to have one witness list for this particular matter. You can't have multiple versions through statements of the same set of events, of the same crime, and at the end of the day, have no interest in mirroring the two together, even reading what the second record has. Because at the end of the day, it's going to link exactly to your work in which you have to do as a prosecutor at court. If you haven't covered that particular ground, you are going to be introduced to various surprises when a person is in the witness box, and it's going to lead to your case crumbling at the end of the day.
As they've seen, they've introduced a lot of surprises for the prosecutor. Thank you very much, Mpumelelo, as always, for your analysis. That's legal expert Mpumelelo Zikalala from Zikalala Attorneys.